Hey everybody, this is Richard Solomon, and we have former prosecutor, criminal attorney, Stephen Siegel with us. Welcome to the show. Thank you for being with us today.
Richard, thank you for having me back.
And let's talk about a little bit about your career as a prosecutor. I know that you were involved with homicide, sex crimes, crimes against the elderly and children in Queens County. Is that a fair summary?
It's a fair summary. As a prosecutor, my background was essentially in Special Victims Bureau. That's a bureau set up back in the middle 80s, and I think to some extent in different counties today. This Special Victims Bureau addresses itself to crimes against the elderly, crimes against children, crimes against women, rape prosecution, and that was the part of the district attorney's office that I participated in back in the middle 80s at Queens County.
Okay, so let's talk about criminal cases and criminal law and all that stuff. People find themselves in all kinds of problems with law enforcement. And then, of course, let's go through the whole process. Before they even get to lawyers, usually there's some kind of act followed up by police inquiry. Now, I guess there's different kinds of inquiry. We need to ask you a couple of questions, and handcuffs, and I guess that's a little different. Let's talk about the whole process and what are people's rights and what should they say and do and things like that all along the way.
Well, law enforcement has, of course, the authority to investigate, to evaluate, and to decide whether they have sufficient probable cause to make an arrest. That is arrest discretion. Once a case comes into the system, it comes under the heading of prosecutorial discretion. There are two decision makers. One is the police officer or the detective, or the FBI agent, or some other law enforcement officer who makes a decision that they believe that there's probable cause that crime has been committed and that the individual that they are about to arrest is the party that committed the crime. The police officers are the arms of our criminal justice system. The district attorney's office is in my view, the conscience, the entity that evaluates the evidence and makes the ultimate decision as to punishment and the level of prosecution. Once a police officer or other law enforcement official makes an arrest, the district attorney then reevaluates the arrest, evaluates the evidence, and makes a decision, A, whether they wish to prosecute, B, whether they want to prosecute as a felony or a misdemeanor, and C, what level of felony and what level of misdemeanor they think is appropriate. Back when I was an assistant district attorney, and I was 24 or 25 years old, and I'd be working midnight to 8 in Queens County.
That's midnight to 8 a.m.
Yeah.
Oh, God.
we were going 24 hours a day back then. I would be pulling up in my 1983 Montego about quarter to midnight, and I'd be watching the lights on Austin Boulevard in Queens, one by one, going out as people were going to sleep, and I was starting my day. But I do recall a seasoned detective, probably a little bit older than I am now, who comes to me with a burglary, and he tells me it's a burglary, let's say 1, first degree. And I look at him, and I've had about 16 minutes worth of experience, and I tell him that I think it's a burglary, second degree. And he went to his gun, and he took out a bullet, and he tossed it onto the desk. It was lead, and it made a thump like a paperweight. And he said, "Son, I have bullets older than you." And we wrote that up as a burglary first degree.
Wow. What is the difference between a violation, a misdemeanor, and a felony? And what does it matter?
Essentially, you've covered the three areas of criminal offenses. A violation is a violation of the law that can be punished up to 30 days in jail. A resolution of a violation, should somebody be convicted of a violation or plead guilty to a violation, that would not hold a criminal conviction on the record of the individual. A misdemeanor carries up to 1 year in jail, And a guilty plea or a conviction to a misdemeanor would be a criminal conviction. And the third level is a felony, which is the most severe of the levels of criminal offense we have. A misdemeanor can be one of two levels. It can be an A or a B misdemeanor. And a felony can be anywhere between A and E felony, E being the less severe and A being the most severe.
What's the difference between an A misdemeanor and a B misdemeanor?
A significant amount of time in jail and exposure. I will tell you that...
Which is the worst one? B?
Oh, A is the most severe, and once you get to the A felonies, there are capital offenses which extend somewhat beyond. An attempted crime always brings that crime from one level to the other. So an attempted A misdemeanor would be a B misdemeanor.
Wow. Oh, by the way, for station ID purposes, this is Richard Solomon on Taking Care of Business with my special guest, Stephen Siegel, attorney at law. And we're talking about criminal defense, and criminal prosecution today. If people have criminal questions, can they call you?
Of course. You can always reach me at 516-521-8600. My email is Stephen with a V, S middle initial, Siegel, Siegel, at Yahoo.
.com.
.com.
What kind of criminal cases do you handle?
I have handled cases anywhere from very, very small cases to I have tried murder cases. I have defended murder cases. I've defended rape. I've defended sexual misconduct. I've defended misconduct of a sexual nature amongst medical care providers. I have defended physicians charged with Medicaid fraud. Any number of different fact patterns. I've represented individuals who have starred in movies that were very popular and very well known. I once represented a well-known manufacturer that a lot of people would recognize had I given the name.
Wow. Where does the grand jury process come into all this? We watch all these Law and Order type shows. What's the role of the grand jury, and where do they fit into the timeline?
Well, that's a very good question. The grand jury is a buffer, theoretically, against prosecutorial misconduct. The most energetic, and motivated prosecutor who wishes very, very much to bring a certain level of charge against an individual, theoretically is limited by the judgment of you and me and the rest of our peers who are non-attorneys. So theoretically, should a prosecutor feel that he has the authority evidentially,
whatever. It's an SAT word, people.
that he has sufficient evidence to charge somebody with a certain level of crime. And he presents a case to the grand jury. The grand jury may very well say, I don't see it the way, we don't see it the way you do, Miss or Mrs. Prosecutor, that you think it's a, going back to the first thing I told you, it's a burglary second degree and not a burglary first degree. And we're just not going to charge what you think we should charge. Now, the grand jury is an opportunity for a criminally charged defendant to stand in front of 16 to 23 citizens and make his case separate and apart from what the district attorney thinks is appropriate, and say to the members of the grand jury, please, this is my story, these are the facts, this is what happened to me, this is what I was thinking, this is what I intended, and please give it extra careful thought before you bring back an indictment against me.
Does every criminal defendant have the right to appear before a grand jury?
Criminal defendants who are charged with felonies have a right to go before a grand jury.
Do they often take that advantage of that right, or do they take advantage of the other right, which is to remain silent?
That's exactly the issue. You hit on it right on the head. A criminal defense attorney, in conjunction with his client, in reaching a unified decision, has to weigh the advantage of attempting to convince a grand jury of his innocence or the insufficiency of the evidence, as opposed to early on laying out their side of the story. In a criminal trial, one of the very few advantages that a defendant has is to wait, hold back, listen to what the prosecution and the prosecution's witnesses and evidence show, and then, at the end of their case, present his view, taking into account what's already been established and asserted. Once you've taken a position at the grand jury, you lose that slim, albeit still valuable, advantage of it being a defendant, if there is an advantage of being a defendant.
It's hard to be, I guess, it's funny, when you see a caption, I guess that's the way we call cases for people out there who aren't lawyers, it's called a caption. It's the title of a case. It's the people of the state of New York versus John Smith. That's like, the United States of America versus John Smith. It's overwhelming resources and power, and sort of the perception, even though we have a motto and a judicial system based upon, innocence until proven guilty, I tend to feel that the general public kind of feels, well, if you were arrested, you probably did something wrong.
That is certainly a bias, and when you pick a jury and you're starting a trial and the judge asks the panel, has anybody here been the victim of a crime, have a relative who's a victim of a crime, or a friend or a neighbor who's a victim of a crime? At least back when I was prosecuting and defending cases in Queens, there weren't enough arms and legs to get up in the air to let the judge know how victimized they and their family were. Now, the next question, of course, is can you still be fair to my client? And the answer, if for no other reason for political correctness, is sure.
Of course I can be fair.
I can be so fair that I'm going to send your client so far away that he will be such a fair distance away from me and everybody I love that I think it'll be a fair result.
Exactly. So let me ask you this. You now somehow have some interaction with the police. There's going to be some kind of questioning. I guess the choices are they can question you and they can arrest you. What should you do if you are not the police in that situation?
Well, I will tell you this, that it is a natural reflex for people in the face of authority to attempt to cause that individual in authority to think well of them. And even the most lawyer-sensitive, civil rights-aware citizen faced with a police officer or a detective who takes them aside, whether it be a car stop or some other investigation, and says, look, I'd like to have a word with you regarding a certain investigation. It takes a certain constitution to say, officer, I have nothing to say. I want to consult with my attorney. This is my attorney's name. This is his phone number. If you have enough evidence to arrest me, I know you're going to arrest me. If you don't have enough evidence to arrest me, take the matter up with my attorney. It takes a certain constitution. Most of us, faced with authority, wanting very much to satisfy authority, not to cause ourselves even more trouble, may find a middle ground and say, well, sure, I'll be happy to discuss that hit and run that happened about 7 miles behind me on the interstate. Prudent response, more often than not, would be to get legal counsel. We
all watch television, and I believe the term that they use on TV is lawyer up, that the person lawyers up. And it seems that the big game that you see on TV is that the police do everything possible to discourage you from lawyering up. If you're in that, if art is imitating life and you're in the situation where you need to lawyer up, how do you not upset the police officers by asserting your right to counsel and still insist upon it nonetheless?
You know what? Being focused on what the right decision is, notwithstanding that it's not the easy decision. Most of us who are interfacing with authorities don't have a lot of experience with it, and we tend to respond quite deferentially to authority. But a strong constitution and the ability to make the right decision over what's an easier decision should prevail.
So, for those who are listening, what's the magic words? What do you say to the police?
In all due respect, officer, before we discuss any of the things you'd like to talk about, I'd like an opportunity to talk to my attorney.
And do they have to afford you that right?
They do if they want to be allowed to use any statements you make against you.
Hey, this is Jeff Matson of Dark Star Orchestra, and you're listening to Richard Solomon on WCWP 88.1 FM.
What's the story with the Miranda warnings? I mean, we used to watch Adam 12 and all that stuff, and it seemed as though, let's see, the two officers, I can't remember their name, from the Los Angeles, they would always like read your rights and things like that. It was like Reed and McCoy or something like that. And we learned from watching television the Miranda warning. But it seems as though the Miranda warning has been sort of cut back. Like, well, if they don't give it to you, you kind of know it anyway. And there's been some cases on that. What is the Miranda warning? What is it supposed to do? And what does it do for the person who's being told about the Miranda warning? What happens if they're not read the Miranda warning?
Well, there are two levels of a law in the area that we're talking about. There's the federal and there's the state. New York State historically has afforded criminal defendants broader protections than the federal government in many respects. What we're talking about here is police acquisition of evidence against an accused, under what circumstances the police can acquire that evidence, and in the event that it's acquired in a way that violates the constitutional rights of the accused, to what extent will that evidence be suppressed? What's interesting as a criminal defense attorney is that the most pedestrian automobile accident affords the litigants tremendous opportunity for discovery. A car accident plaintiff can ask the defendant for hours on end what he was looking at before impact, where his hands were, what his radio was playing, what kind of shoes he was wearing, what the weather conditions were, how many feet from the corner did he begin his turn. While a criminal defense attorney, with his entire life hanging in the balance, he has next to no discovery rights. He cannot, before trial, in deciding whether to take a plea, have his lawyer question the arresting officer and ask him questions such as, "Officer, when you saw my client allegedly with controlled substance in his hand on the corner, how many feet were you? Where were you standing? What was your vantage point? How much? What part of the controlled substance was visible?" None of that exists here in New York State. So what does exist is the right to bring a hearing to suppress evidence. That is your opportunity to call the arresting officer under oath, generate a transcript, and assess and put on the record what he saw and what he did. Now, the purpose of the suppression hearing is not necessarily to give, and not beyond necessarily, is not intended to give the defendant discovery, but it's the only opportunity to obtain discovery. So, for instance, to go a long way back to your question, if there are statements attributed to the accused by the police officer, and you have what they call a Huntley hearing, that is an opportunity to ask that officer the facts which surrounded the acquisition of the statement. Did you threaten the defendant? Did you induce him? Did you promise him? Was he advised of his rights? Same thing for the obtaining of illegal substances or fruit of a crime. That's called a MAP hearing. A Wade hearing, W-A-D-E, is a hearing to determine whether the identification was tainted, whether the officer somehow suggested that the accused was the perpetrator. So the importance of these constitutional rights, whether it be Miranda, whether it be the search and seizure, whether it be the propriety of identification procedures, these are devices that both serve the criminal defendant an opportunity to attack the manner that the evidence was acquired, as well as get some sort of discovery, which statutorily is not provided.
One thing I've noticed, especially in DMV court, is the police officer takes out his little pad, her pad. They read very stoically and in monotone this is Police Officer Jones, Field Number 2, Battalion 3, Precinct. I was doing truck patrol, and I saw the offending vehicle. It's almost like they've rubber stamped, right out of the computer, the whatever they want to say, and they just kind of insert your name, your license plate, you're this, you're that. And it just seems like no matter what they say, their statements are fine and they're credible and yours are not. How do you break past that?
I will tell you something interesting. I sit as a judicial hearing officer in Hempstead, Long Island. On occasion, maybe once or twice a month, sometimes once a week. And I've seen those, as a presiding judge, I've seen the prosecution advance certain cases, and I've heard motorists give their side of the story. And I will tell you, at least in my courtroom, tremendous attention is given to the facts and the evidence. It's not a rubber stamp where I sit.
You're either given the Miranda warnings or not. Are they allowed to frisk you? Are they allowed to search you?
Under some circumstances, when a police officer comes to the conclusion that there is probable cause or reasonable suspicion, there are some things short of a full search that an officer can do.
Okay. I remember there was a case called Terry versus Ohio where they were allowed to pat you down if they saw a bulge. So, of course, police officers were starting to say, well, I saw bulges because they were afraid of weapons. But what are the sort of the things that people should just be aware of if they're in cars? Are they allowed to be asked to step out? What about field sobriety tests? How does DWI work? Talk just in general. How does all that stuff work, and what should people be doing? And
okay, what's interesting, something that a lot of people do not know, is that when you are arrested for DWI, what is being initiated is a criminal prosecution of you. In addition, there are many counties that will commence a parallel action for civil forfeiture. Now, that is a completely different and parallel litigation. In order to be convicted of DWI, the prosecution has to prove their case, beyond a reasonable doubt. But in order to prove that you were operating a vehicle intoxicated for the purposes of taking your car, they only have to prove their case by a preponderance of the evidence.
Okay, now a preponderance means 50-50 plus one feather?
Correct. More likely than not. So let's say, even assuming you were to litigate the criminal DWI charge, driving while intoxicated, and the people of the state of New York have insufficient evidence to convict you of that, the prosecution may still have sufficient evidence to prove more likely than not that you operated your motor vehicle in an intoxicated manner. You may win the trial that involved a criminal conviction potentiality and lose your $29,000 Toyota.
Well, or worse. One of the interesting questions, sort of equal protection. I'm driving a Yugo that's 30 years old, and someone else is driving a Lamborghini.
Exactly.
It's sort of the guy with the crummy car. Maybe they don't want to grab it because it's really not worth. The towing costs more, for the prosecution and the storage, whereas the Lamborghini. So I wonder if there's sort of an equal protection problem. I know there's been numerous challenges, and I think that the courts have sort of denied all the motorist challenges. But it's an interesting academic question: that is the punishment really fair if people lose different value cars for the same offense?
Absolutely.
At a DWI. And of course we discourage heavily any intoxicating driving or anything like that. But people do get pulled over for all kinds of things. If they're sleepy or if they have a medicine or whatever, because they're suspected of being DWI. What do you do and say, and what do you not do and say when you're pulled over?
Well, you always cooperate with the police officer. A refusal to undergo a breathalyzer or some other manner of chemical test for intoxication has both criminal and Department of Motor Vehicle adverse consequences. So you really have to give those decisions, a decision not to cooperate, a hard thought. Once you've taken a field sobriety test, they then have probable cause to make an arrest. There are two different theories that can be adduced and advanced against you. One is whether you fail a breathalyzer test, and the other is known as common law DWI, which is that the officer can come to the conclusion that you're intoxicated based on your affect, the alcoholic beverage scent on your breath. They can make it based on your gait and on your speech. These are two different counts of the same charge.
Has the advent of video equipment in police vehicles changed the dynamic of the DWI pullover?
I will tell you that the advent of DWI filming of sobriety tests back when I was a prosecutor was good footage for Christmas parties.
I've often noticed that in DWI cases, maybe because people are a little looser, tend to say very damaging things to the police. Is that your experience?
Look, certainly drunkenness is not the best posture to be in when you're answering questions of the authority. I mean, you can imagine being drunk and having the IRS go through your checkbook. It's just not a good idea.
That's pretty cool. I have to remember that for those kinds of cases. Assuming you're arrested for DWI, and let's say, do they actually tow your car? Or do they have your car towed, or they just leave it there, or that's up to the discretion of the police in different counties?
Purely discretion of the police officer. Once you are arrested, you are brought for arraignment, and at the arraignment, the judge will evaluate, based on the presentation of the district attorney, the strength of the case and your flight risk. And based on that presentation and the presentation of your attorney, he will make a decision, or she will make a decision, as to whether to set bail.
I hear our theme music, which means that we have to take a break. This is Richard Solomon. This is Taking Care of Business. We will be right back. You are listening to Taking Care of Business with Richard Solomon. If you are just joining us, I'm here with Steve Siegel. We're talking about criminal matters, arrests, prosecution, defense, DWI. We're now talking about arraignment and bail, and all that really interesting stuff that we see on TV that's not necessarily true as it is in art as it is in life. The purpose of bail is to determine whether you're going to show up again at your court hearings, right?
It assures to the court that there's a greater likelihood that you will not flee the jurisdiction, that you will return and resolve the case.
How does the court make that determination? Is it based on who you are, your resume, or your good looks and charm, or something a little bit more objective?
Well, make no mistake about it. Judges are people like each of us, and they will get an impression based on the way you present yourself. Your affect, often the way you seem to be reacting to the circumstances. They will respond to your attorney's arguments. Judges have feelings and values and life experience, as do all of us. The judge's inquiry would be, or what would be advanced by your attorney, would be whether you had a history of fleeing the jurisdiction. Certainly, if you have a history of warrants, it would encourage the judge to set bail. Whether you have roots in the community, if you don't have a steady address, if you've been at the same address only for 30 days, if you don't have a job. Certainly, if you have employment, it bodes better for you because you have a reason to stay in the community, separate and apart from the criminal prosecution. If you're married, if you have children, people travel faster when they travel alone. If you have a wife and child, it's less likely that you'll pack up and bring each of them to a jurisdiction outside the authority of the state.
Or is there any rules about how fast you are to be arraigned? And what happens to the arraignment? Do they actually tell you what you're being charged with?
Back when I did a lot of this criminal work in the 80s, it was a 24-hour rule, which was the standard but not often abided by. That would be 24 hours from arrest to arraignment. If you're arrested, what you can expect would be that they will bring you to a centralized location for booking, for fingerprinting, to evaluate up in Albany what past criminal charges you've had and how they were resolved, whether you had a history of warrants. There will be some other paperwork. There will be some photographing. You'll be placed in a pen with other similarly situated defendants, arrestees. You'll be provided with a thinly meated sandwich and some what they call in camp bug juice. Cooperate, be respectful. You are in a position where it's valuable to be deferential. When you come out, when they said bail, if they said bail and your family does not have the cash in court, they can post it at any of the jails. The jails are in each county of the city. They are housing for defendants who are awaiting trial, as well as convicted defendants awaiting a state placement in the state system. A conviction that carries over 1 year in jail is a state incarcerated defendant. So your family member would be well advised to bring a certain amount of cash right there to arraignment court. So in the event that the court posts bail, you can go home right away, assuming you have enough cash. ATM cards are very valuable in this situation.
If you're a juvenile as opposed to an adult, and I guess the cutoff is 18, how are the systems different?
Well, there are certain offenses that a juvenile can be charged with a crime. For other offenses, juveniles are prosecuted in family court with different punishments and different penalties. A juvenile can resolve their case with something known as a youthful offender finding. A youthful offender finding is a finding that substitutes for a criminal conviction. A defendant who is afforded youthful offender status has his conviction wiped out and replaced with a youthful offender. It's an act of generosity by our legislature to young people who make poor choices and hopefully won't repeat those choices.
I remember reading in the New York legal publications about drug courts and violence courts as a new thing. But I guess at the very end of it it's still these are problems. What do you recommend to people to do beyond the criminal case itself as the lawyer to sort of get help in other things? I know that we had a show on Gamblers Anonymous, for example, 1-800-GAMBLER, and that's at TCBRadio.com. Look at the archives. That was a very powerful show. In fact, the Suffolk County prosecution asked for like 20 copies of that show, and they gave the show on Gamblers Anonymous to folks out there. Is there anything along those lines you'd like to sort of share as either as an insight or?
I will tell you that we, as a community, which include judges, we value and respect acts of redemption. And if you are a criminal defendant who is charged with certain types of crimes, it would behoove you to address them for your own life experience and life satisfaction and to have as fulfilling a life as you can. And secondly, it's something that can be advantageous in attempting to resolve your case with a plea bargain, which brings us to another subject.
Which is my next question. How does the whole plea bargain thing work? I have like a case, for example, involving some shoplifting. They're claiming that my client was involved in a supermarket incident. And what's amazing is sort of the just general assumption that your client's guilty and all these other things. And I actually filed a civil action. I was so frustrated by the criminal process that I filed a civil action to get all these surveillance tapes and all those other, because I wanted to prove the innocence of the people involved. And I served a subpoena in the criminal case. The other side, the complainant wouldn't produce it. I went to the Supreme Court and did the same thing. And yet, when it came to sort of negotiating with the prosecution, they offered a deal that I thought was fairly crummy. And I actually said to the judge, "You're just assuming they're guilty. What if they're innocent? It's not. The deal you're offering is a horrible deal if you're innocent. How does the whole plea thing work? And what's the dynamic? And prosecution officers seem to be very burdened and busy, and everything's like soundbite and sentence reports and this and that. What do people need to know about plea bargaining?
It is not an accident that within our justice system, not just criminal justice system, that most litigation resolves itself in settlement. The reason is both sides have an opportunity to lose and an opportunity to expend a lot of funds in litigating, and they have to weigh the advantage in proceeding as opposed to the advantages in settling. Having said that, anybody in your listening audience who feels that under no circumstances can they imagine a criminal defendant who is innocent pleading guilty, they are living with a very strong misconception. The danger, the exposure, the possibility, however slim, that a jury of their peers may find them guilty for any number of reasons, separate and apart from the actual guilt or innocence, are so prevalent that there are many occasions where innocent clients find themselves in a position of pleading guilty. For instance, depending on the jurisdiction, depending on the presentation, the way a criminal defendant looks, the way he conducts himself, what kind of prior criminal history he had before the offense that he's being charged with, how motivated the witnesses are, how good his experts are, how good his lawyer is. Perhaps he or she, as a criminal defendant, has a lawyer that is just not interested or not talented or not motivated. Perhaps the prosecution has a terrific prosecutor. Perhaps on a shooting case, the best expert that this criminal defendant can find is somebody with an inability to communicate well with a jury, whereas the people have access to perhaps better experts. There are so many factors that come into whether somebody wins or loses a criminal trial that there are certainly good reasons why innocent defendants find themselves contemplating guilty pleas.
Do you often find that better resourced defendants do better because they can hire more experts and do more investigation?
No question about it. We can just look at the recent Duke result, Duke University result, without being a tremendous student of the nuances of the prosecution. Can you imagine how many criminal defendants are placed at trial or forced to plead guilty because they don't have the exposure, the publicity, or the money as these students had?
Just for the audience, what you're talking about, because this show is aired much later on. Could you put this? What case are you talking about?
I'm speaking of the Duke University lacrosse litigation, in which one prosecutor felt very strongly in support of the prosecution of three men at the end of the prosecution process. He was removed, or he left his position as a prosecutor, and a different individual came to be in charge and make a decision that there was insufficient evidence to go forward with the prosecution. This is a case that got tremendous attention in the press, tremendous scrutiny. There was tremendous pressure on all parties to resolve it. But think of the hundreds and hundreds and thousands of cases in which nobody's looking at, and what kind of pressure is brought on the criminal defendants to either take a plea or go to trial. And just to put it all into perspective, let's say your listeners are the lawyers, and let's say they have a client who insists that they're innocent, and the prosecution is offering a sentence of probation or a conditional discharge or an unconditional discharge in exchange for a guilty plea. But if that individual loses at trial and they face days, months, years of incarceration, it would take a very, very special constitution to say, I am innocent, notwithstanding the lenient offer of the prosecution. I'm going to roll the dice and prove my innocence.
When you are arraigned as guilty or not guilty as your plea, and I guess it's automatic that if people just plead not guilty, what's a nolo contendere plea? What does that mean? Or no contest? And is that the equivalent of like saying guilty, but I just don't want to like call it that?
In New York State, it's called an Alford plea, which is resolving a case without an actual allocution to the criminal offense. An allocution is when you speak to the judge at the time of plea, in which you essentially convince the judge that you are pleading guilty because you are in fact guilty. The judge will ask if he may allocute the defendant, and then he will ask him, sir, could you tell me what happened on this date, time, and place? If the defendant indicates that he was innocent and he was at that location doing no criminal offense, a judge will refuse to accept the disposition. So an Alford plea allows a criminally charged defendant to dispose of his case without an actual allocution.
How often is that seen?
Very infrequently.
Yeah, because I've never heard of it. And I watch a lot of TV. And my wife watches a lot of TV. Are there instances where you would not have a jury in a criminal trial?
Oh, absolutely.
What would those kind of cases be? Would you is that called waiving a jury? Do you actually
and asking for a bench trial?
Why would you do that?
The attorney, in consultation with his client, would attempt to assess the nature of what the prosecution will be presenting and attempt to assess whether a fairer, more sober, more unbiased evaluator of truth and evidence would be 12 contemporaries sitting on a jury or a judge. And of course it'll have a lot to do with which judge and what the attorney's sense of the orientation of the judge would be.
So let's talk about, in the last 10 minutes, the criminal trial process. I assume they give you a chance to plead, and if there's sort of no plea arranged or achieved, the next and final step in the process so far is to go to trial.
Yes, and when you go to trial, your lawyer should take the time to A, give you his opinion as to the likelihood of success, B, go through the levels of punishment that would be available depending on the level of conviction, C, discuss with you whether you will or will not testify. That is a decision that is the absolute right of a criminal defendant after consulting with his attorney. Decide on which witnesses will be called, and establish the contingencies as to under what circumstances what part of the defense case would be advanced, which witness will be called. Once the trial starts, it is the prosecution's burden, obligation, responsibility, threshold to prove their case beyond a reasonable doubt. The defendant has absolutely no obligation to do anything other than to maintain his innocence and attack the prosecution's case and argue that the people of the state of New York have not proved their case beyond a reasonable doubt. Should the defendant wish to go forward and to put on their case, they can call witnesses. Subject to the court's approval, they can call expert witnesses. They can testify. They can call character witnesses. They could present computer-generated depictions of the incident. They could put on a case. At the end of all the evidence, the case is given to the jury. The jury is advised by the court, actually directed by the court, as to what the law is. That is called a jury set of instructions. The judge reads the instruction. When I say destruction, it may be destructive to the defendant. Reads the instructions to the jury, and the jury is sworn to follow the law, whether they agree with it or not. The jury is the sole judge of the facts. The judge is the sole and exclusive judge of the law. And being a juror is an extraordinarily powerful, potent, and important position.
How important are experts in criminal cases?
Depending on the case, it may have tremendous probative value. Probative amongst lawyers is a term meaning evidentiary value.
What kind of experts would you normally say? I know there's DNA evidence, there's ballistics evidence.
There's accident reconstruction experts. There are crush experts who can evaluate the nature of crush damage to a car and assess speed. Accident reconstruction experts assess tire markings on the roadway, direction and speed. Pathologists can assess the direction of bullets. They can assess distance of where the shots were fired. They can determine cause of death. There are cases in which pathologists have evaluated stomach contents to assess when a particular party died. I've known of cases in which pathologists have assessed heart disease to determine whether the incident generated the death or whether it was a pre-existing condition that was a coincidental development. Those are some experts, fingerprint experts, handwriting experts. There are experts that can assess the statement as to the voluntariness.
Wow. So you go through the trial process, you wait for your verdict. I'm sure the most painful part of the process is after closing statements and waiting for the jury to deliberate. That must be a nail-biter.
Taking a verdict is a singular experience for a lawyer and for a client. I can't put into words or describe it sufficiently to let your listeners understand what it feels like when the moment arises where the judge is summoned quickly and you're in the hallway and the officers call you in and your client's wife is brought in and your client is brought in often from the pens and uncuffed and surrounded in a semicircle by court officers. In the event that it's an adverse verdict, he may want to run. You never know how a criminal defendant will react when he's shocked by a guilty verdict from a jury. So now the officers are surrounding the defendant. The defendant is seated. There's a pounding on the bench. There's an announcement, all rise. The judge is given a note. The judge looks up and says, the jury has come to a verdict. There are 3 minutes, 7 minutes of tension as they gather up the jurors. There's a knock at the door, and the court officer says, the jury is ready. The judge says, is the defense ready? Yes, Judge. Prosecution? Ready. Bring the jury in. Now the parties are looking to see whether the jurors are giving them eye contact. Are they afraid to look into the eyes of the accused? Then the judge said, will the defendant please rise? Mr. and Mrs. Ford, a foreman, or forelady, has the jury reached a verdict? We have, Judge. Could you hand the verdict up? The next 7, 10, 15 seconds feel like 15 minutes.
Does the judge know what the verdict is until that note is handed to them?
Different judges, different courts, different policies.
Okay.
But when they read the verdict, it is a unique experience for everybody involved. This individual, like you and me and some of your listeners, will be leaving the courtroom through the front door, and some will be leaving the courtroom through the back.
Wow. And I guess there's always the appeals process, which is a different story altogether. I assume that the appeals process is very tough because is it more probable than not that once you've lost that it's hard to upset those verdicts?
The answer is yes. I will say that there is a joke that I learned many, many years ago when I was a very new criminal defense attorney, where the attorney communicates to his client before trial that we're going to go all the way and we're going to try the hell out of this case. Loses the trial. Tells the client they're going to appellate division. And they got a great case. We're going all the way to appellate division. And he generates a tremendous appeal. And he loses. He tells his client they've lost. He says, don't worry, we're going to the Court of Appeals. And he brings his documents to the highest court in the state of New York. And they lose there. He says, don't worry about it, we're going to the United States Supreme Court. And he loses. And the client says, where do we go now? And he says, I'm going to lunch.
Oh, that was riveting.
So there's no question that your advocate is your advocate, but you're very much alone, as you are when you're undergoing a medical procedure. You can have the best doctor, the most supportive friends and family, but it's ultimately you and your life.
Well, you know what they say, you come in alone, and you go out alone. It's very true. But you're not alone if you can call Steve Siegel. How do they call you, and how do they get you?
Your listeners can always reach me, 516-521-8600. Steven Siegel, Steven S. Siegel at Yahoo.
Steve, thanks so much for sharing all this great information. You've been an incredible guest. Thanks for your time. We'll see you all in a week. Thanks for listening. Thanks for your support. Keep those letters, emails, and phone calls coming. We love hearing from you.
What I really need, some kind of affection. All that I have is this little infection. Yeah. Of need.